you. Good morning, everybody, and you're very welcome to today's meeting of the Licensing Subcommittee, which is Thursday, the 28th of April, 2022. The first task I have is the election of chairman. My name is Councillor Jude Spatt, and I'm the chair of the Licensing Committee and the presiding person for the purposes of this Licensing Subcommittee today. So I'd like to ask, please, for a nomination for chair from our subcommittee members. Do I have a nomination, please?
Yeah, nominate yourself, please, Chair.
Thank you, Councillor Kelsey. And may I have a seconder, please?
Councillor Farquhar.
Thank you.
I second that, Chair.
Thank you very much indeed. So duly elected, I'll now move on and I'll ask our clerk, Mr. Tyler, if he'll take us through housekeeping. Thank you.
Many thanks, Madam Chairman, and thank you to everyone here this morning. Please note that this meeting of the Licensing Subcommittee is being recorded by the Council for live broadcast and will be published on the Council website for a minimum of 6 months. In order to ensure the meeting is managed effectively, please could everyone present follow these ground rules for speaking. Only speak when invited to by the chairman. State your name before you speak if you have not been introduced already. Please ensure that you unmute yourself and always turn on the video function before speaking. Please mute your microphone when you have finished speaking. After each party has made their representation, the chairman will ask each person in turn if they have any questions or comments. However, if at any point you would like to speak again, please use the raise your hand function at the top of your screen. Finally, please ensure background noise is kept to a minimum and that mobile phones and other devices are turned off or switched to silent for the duration of the meeting. Thank you, Chair.
Thank you very much, Mr. Tyler. So apologies. We don't have any apologies with regard to the substantive subcommittee, but we do have an apology from one of our reserve members, Councillor Bagwell. Regrettably, she's suffering from long COVID, and the best thing to do is to be resting at home. So thank you very much, Councillor Bagwell. We send our best wishes to you. Moving on then to declarations of interest, and I will ask each committee member in turn as to any declarations of interest. Councillor Farquhar, any declarations of interest?
I have none, Chair.
Thank you. And Councillor Kelsey?
None, Chair.
Thank you. And for completeness, I have no declarations of interest either. So you will go on then and you will see item 4, which is protocol for public speaking. And if you'd note that the revised protocol for virtual meetings has been circulated with the agenda sheet, but I'm sure you're used to it by now. So moving on then now to the one of the substantives, which is item 5, which is Sandbanks Beach Cafe kiosks. And an application has been received for a premises licence to permit off sales of alcohol between the hours of 10 AM and 11 PM each day of the week from 3 kiosks within the remit of Sandbanks Beach Cafe property. And the matter is brought before the subcommittee for determination today. I'm going to now introduce our participant who's here today who'll be taking part in our subcommittee. So I'll firstly introduce myself. My name is Councillor Jude Spatt, and I'm chair of the Licensing Committee, and I'm chair of this subcommittee for the purposes of today's business. And my ward is Creekmore, Hilborn and Waterloo. Councillor Kelsey.
Yeah, Councillor Kelsey, member for Eastcliff and Springdale, and a member of this committee for today.
Thank you, Councillor Kelsey. Councillor Farquhar.
Councillor George Farquhar, I'm representing Boscombe East and Folkestone. I'm a councillor and I am a member of the subcommittee panel today.
Thank you very much. And in the background, our Councillor Brian Dion, who has turned up as a reserve member just in case one of the subcommittee members were not able to be present. So again, Councillor Dion, thank you so much. You were here yesterday. Bless you. Thank you for turning up. You are more than welcome to stay if you so wish. And thank you very much for your attendance. Moving on then to our officers, Sarah Rogers, please.
Good morning, Sarah Rogers, Senior Licensing Officer for BCP.
Thank you. Alan Parr.
Good morning, Alan Parr. I'm legal advisor to the committee, but I take no part in the determinations.
Thank you very much. And Mary Almeida.
Good morning, I'm Mary Almeida and I'm shadowing Alan today for this subcommittee.
Thank you. Mr. Taylor, we've already heard from you, but please do introduce yourself.
Morning. Yes, Joseph Tyler. I'm Democratic Services Officer and Clerk to this subcommittee meeting. Thank you.
I will attempt to pronounce your surname correctly the next time I speak to you, Mr. Tyler. I apologise. Mr. McNann.
Chair, are you referring to me? Sorry.
I am. Mr. McCann.
McCann, yes, sorry. Yes, solicitor for the applicant. Good morning.
Okay, yes, we are. I'm doing very well on the mispronunciations today, aren't I? Haven't got my glasses on, vanity, you see. Mr. Wilson.
Good morning, Lee Wilson, Operations Director for Rockwater, Sandbanks and Branksome, and also DPS for the Sandbanks Cafe.
Thank you very much. In addition to Democratic Services officers are providing technical support in the background, but they won't take any part in the hearing. So I just wanted to check that everybody who's given notice of their intention to speak has been identified today, and anybody who wishes to withdraw a representation or wishes not to speak has been identified. So are we all content? We are. Moving on. So I'll just go through the procedure for today, and the licensing officer will present the report. The applicant will then make their application. Questions of the applicant by all party and members of committee going first, and then the responsible authorities or other persons will make their representations. Questions of the responsible authorities or other persons and members of the subcommittee will go first. All parties will be given an opportunity to sum up, with the party who spoke last to go first, and then the hearing will conclude. The subcommittee will then deliberate in private with our legal advisor and our clerk present. Notification of the subcommittee's decision will be given within a period of 5 working days, beginning with the day or the last day on which the hearing was held in accordance with the regulations, and that is today, the 27th of April. Is it 27th or 28th? It's the 28th. I was close. The notification of decision will include information about the right of appeal as appropriate, and we will ask our legal advisor to give that advice at the time. So I'm just now going to ask if everybody is content with that procedure, and I will go through as listed. Mrs. Rogers, are you content?
Yes, I am. Thank you.
Thank you. And Mr. Parr? Are you content?
Yes, I'm content.
Thank you. And Mrs. Almeida?
Yes, I'm content. Thank you.
Thank you. And Mr. McCann?
Yes, thanks, Chair.
And Mr. Wilson?
Yes, I am. Thank you.
Thank you very much. And finally, and very importantly, just remind all parties speaking not to repeat the information which they've already submitted in writing, but to expand on their written representations. And all questions will be asked through me, the chairman, and I will direct the meeting, and there'll be no cross-examination of parties, please. So I'll now ask our licensing officer, please, Mrs. Rogers, if she would present her report. Thank you, Mrs. Rogers.
Thank you. This is an application made by Rockwater, Sandbanks and Branksome Limited to permit off sales of alcohol from kiosks near to the Sandbanks Beach Cafe between the hours of 10 a.m. and 11 p.m. each day of the week. As a result of the consultation, 3 representations were received under the grounds that to grant the application would undermine the licensing objectives. During the consultation period, Dorset Police undertook mediation with the applicant, who have now amended the proposed hours to provide alcohol between the hours of 11 a.m. and 9 p.m. each day of the week, and the inclusion of additional conditions. It was also agreed to remove kiosk number 3 on the plan, therefore no longer forming part of this application and is not to be licensed. This is the kiosk to the far right on the plan. Details of the conditions that have been agreed have been circulated prior to this meeting. The agreement made with Dorset Police was sent to all those who had made a representation, which resulted in 2 of the representations being withdrawn. There is therefore only 1 representation remaining. This person wishes to remain anonymous and had requested Councillor Haynes to represent them, but unfortunately she's unable to attend today's meeting herself. No representations were received from any of the other responsible authorities. Should this application be granted and the applicants fail to operate in accordance with their licence and any conditions attached to it, they will be aware that any of the responsible authorities or any other person may request a review of the licence at any time. Thank you.
Thank you very much, Mrs. Rogers. So, members and those present, are there any questions on points of fact for Mrs. Rogers? Councillor Kelsey?
Not at this time, Chair. Thank you.
Thank you very much. Councillor Farquhar?
None, thank you, Chair.
Okay. Mr. McCann, do you have any questions on points of fact?
I don't, Chair. No, thank you.
Okay. And Mr. Wilson?
No, I don't. Thank you.
Thank you very much. So moving on now to our applicant, Mr. McCann, who's speaking on behalf of Rockwater. So in your own time, Mr. McCann, you have the floor. Thank you.
Yes, thank you very much, Chair, and good morning, everybody. Unfortunately, Chair, for you and one of your colleagues, this will be like Groundhog Day to a certain respect, because we had a similar application, albeit with more objectors yesterday. But obviously this is a standalone application, and I appreciate that it's completely separate. So unfortunately, I will have to go through some of the same points I made before, if that's okay
Yes,
with
please,
you.
we must treat it as obviously a separate application, so we're quite happy to hear all that again. Not a problem. Thank you.
Good, thank you. And hopefully you will have seen the mediation statement that we lodged. Again, it's similar to one that we lodged in respect of Branksome, albeit slightly briefer. But I'll let you read that in your own time. Lee is here, as before, to answer any questions you might have and chip in where necessary. But I'm hoping to address you for as little time as possible. We almost didn't have a hearing. The mediation went well. We've got one outstanding representation. Unfortunately, they're anonymous, so we're not sure exactly where they live. The outstanding rep is at page 40 of your bundle. It says they register their objection in respect of the application for Branksome Beach Restaurant Kiosk, which is the application was heard yesterday. And it says, should a similar application be lodged for Sandbanks, the same criteria will apply. So I think it's just a relevant rep, but obviously it's a general objection for most applications. With this application, it concerns 2 kiosks, as has been explained, either side of the Sandbanks cafe restaurant. If this license is granted, the intention is for one of the kiosks to focus on fish dishes and soft drinks and alcohol, and the other one to focus on more general food. Now, the idea between licensing 2 of the kiosks is that what we wanted to avoid is having one kiosk licensed and one not licensed. So you'd get your lobster roll from one kiosk and have to walk around the other side of the restaurant and get the alcohol. So that is the reason why we're applying to license both. I'm hoping just to address you on 4 points this morning. Firstly, to explain a bit more detail why we're making this application. Secondly, to say why we believe that the operation of this kiosk will uphold the licensing objectives. Thirdly, to touch upon our experience of running kiosks. And fourthly, just to talk very briefly about that sole remaining representation. So why have we made this application? Well, what's happened in the past is that there's been off sales, takeaway drinks taking place from the restaurant itself. So this is the kiosks are just either side of this restaurant. Now, what's happened in the past is that there's been a temporary bar that's been set up in the patio, which is within the demise, within the licensed area at the front of a restaurant. And they've been selling drinks from there, or people have been going in to the restaurant and getting takeaway drinks to consume elsewhere. Now, that license, the restaurant, is very broad indeed. It allows sale of alcohol for takeaway from 10 a.m. to 11 p.m. And also in terms of conditions, it's got a condition referring to refusals log, challenge 25 and a no glass policy. So on one hand, that sounds great. Why don't we just carry on doing that? But there's 2 difficulties. I mean, firstly, having a temporary bar set up on a patio doesn't look very professional. To be honest, it looks a complete mess. And I'm not sure if you, your colleagues, saw it over the last few years, but we're looking to avoid that look of some maelstrom of people just crowding around a temporary bar. And secondly, if we were to not do that and have people coming into the restaurant, again, you have issues in terms of management, because you've got harassed waiters and waiters trying to serve the customers who are paying good money to sit down and have their lunches and dinners and drinks, etc. And then people coming in, queuing in the wrong place, asking for takeaway drinks, and it's just a complete mess. So that's why, even though if this application is granted a sort, it will have reduced hours, significantly reduced hours, and also far more conditions placed on it. We think that operationally and for purpose of licensing objectives, it will work better. So in terms of those additional restrictions, you've got the hours. We have agreed to reduce the hours to 9 p.m. From 11 p.m. And we think this will make a big difference. And we say this is one of the key reasons why Dorset Police were happy to withdraw their representation. At 9 p.m. on a sunny day, the beach can still be busy with day trippers, families, etc. coming off the beach. But we appreciate that at 11 o'clock, you can get a slightly different clientele, and we don't want to be associated with that late night drinking crowd. And the second, and I've alluded to this, is for conditions. that we've agreed and proffered. They're 20 odd. I'm not going to go through all of them one by one, but broadly speaking, they can be compartmentalised into 3 different areas. Firstly, you've got those conditions that limit the number of drinks that can be bought at any one time, the type of drinks and the strength. So we've agreed a condition whereby somebody can only buy 4 drinks at any one time. The beers and ciders have to be below 5.5%. We can only sell glasses of wine. You can't sell a whole bottle of wine in one go. And spirits can't be sold neat. They have to be sold with mixes. So you can have a gin tonic, but you can't have a double gin, for example. Now, all these conditions are to encourage customers to drink in moderation and not simply drink as much alcohol as they can in the shortest possible time. Then secondly, you've got the supervising conditions. So we've got conditions we have to risk assess in the busy times, have both SIA and also marshals. And also we've agreed with Dorset Police and we've agreed a condition that when we open, if this application is granted 9 PM to 9 PM, our staff will stay on site and around the premises for an additional hour, not only to help with dispersal, but also to help with any litter collection. And then finally, you've got what I call the oversight conditions. And these are conditions that require there to be a refusals log, an incident register, specific staff training, and also a first aider in the vicinity. So they're the checks and balances that we say that if this application is granted, it will better uphold the licensing objectives. In terms of our experience of running kiosks, we do have experience. At Hove, which is the first Rockwater, this is the third one, the second being Branksome. We have 6 kiosks in total, of which 2 are licensed and are licensed until 10 PM. Now at Hove, and as will be the case here, we have specific staff training on everything from marshalling queues to recognising drunkenness, how best to say no to customers, which can be tricky if you're not being trained, and even how to help find a lost child. And certainly at Hove, the alcohol is part of a much wider offer. Food is very, very popular. It's very good. I've tasted it. And even coffee on some days can actually amount to 60% of sales, which is very high. Getting people drunk is not what we do. It doesn't actually go with the atmosphere we're trying to create. And just by way of a small example, our biggest selling beer at Hove is the Rockwater Lager, our branded lager, and that is 4%, which is much weaker than the 5.5% plus you get with the mainstream continental lagers. Now, just to quickly touch on this sole remaining representation, we are relatively new to the area. We have had numerous meetings with residents groups, councillors and other statutory authorities. There's always more people to meet, and we're doing that all the time, and certainly Lee's been very proactive in that respect. We're very heartened to have no outstanding representations from any of the statutory authorities. They are what I would say, and it says in the guidance, the independent experts, and they have many years of experience of knowing what is and what isn't something that uphold the licensing objectives. Now, we were mindful of the representations raised, and we sought to address them in the mediation statement. In terms of the sole remaining objection, in terms of 4 issues that are cited, the first issue is the danger to children from broken glass. Well, that's been addressed by the condition to say we won't have any glass. The second is that alcohol impair the quality of drivers leaving the beach. That's not really a licensing concern, as your legal advisor will no doubt advise you. Thirdly, there's the increase of emergency service from lifeguards from people swimming in the sea. Again, not strictly speaking a licensing issue. And fourth is the concern about an increase in antisocial behaviour. And I think that's where the mediation with the police is very important. They're the experts in that respect, and we've reduced the hours and added further conditions where appropriate. So I'll just wrap up by saying that this is an application to effectively move an existing permission from a patio to either side of a patio from a dedicated kiosk. If this application is granted to sort, we're happy to undertake that we won't have a temporary bar in that patio area. But if that is not satisfactory to you, we're happy to have a condition placed on any licence to say that these new kiosks will not sell alcohol whilst there is a temporary bar in place on the patio of the restaurant licence. Chair, unless Lee, you want to chip in with anything, I'll leave it at that, but of course happy to answer any questions you might have.
Thank you very much. Mr. Tyler, can you ensure that that condition that's just been offered is written down verbatim so that we can look at it later and have reference to it? I'm sure that we'll be happy to accept that should we be so disposed to grant. Thank you. Mr. Wilson, did you want to add anything?
Yeah, all I was going to say, thank you very much, Chair. All I was going to say is I was made aware of 2 out of the 3 representations. Obviously, we know that the third wished to remain anonymous and did meet the 2 people in question during the course of this consultation period. And it was just to say that we as a business are committed to meet with our local community and work with them as closely as possible, because that's actually obviously our fundamental part of our business. I'm just saddened that I wasn't obviously able to meet the third person, but thank you.
Thank you, Mr. Wilson. Okay, so we move on now to questions of our applicant, and I'll go to members first. Councillor Kelsey, any questions?
No, Chair, thank you. I'm quite pleased to see the mediation has been done. It makes life a lot easier for everyone if we can get agreement with all the relevant people in place. So, yeah, good. Congratulations to the guys for doing that. I think they've done a good job in the mediation.
Yes,
Thank you very much. Thank you.
I would certainly concur. Councillor Farquhar.
Yes, indeed. I would. I do have a couple of questions, Chair, if you please.
Okay, thank you.
And I would echo Councillor Kelsey's comments as regards to mediation. I think it's been a very worthwhile exercise, and I know that the police do their job very, very diligently to ensure that residents and visitors are protected by people not upholding the licensing principles or objectives, should I say. The first question is just a confirmation from Mr. McCann, if you please. It may have just been a misspoke. I just wanted to confirm, because when talking about the marshals and the SIA, you mentioned that the hours of operation 9 a.m. to 9 p.m. Was that just a mistake? And I just wanted to confirm that it is hours of operation 11 a.m. to 9 p.m.
They are a slip of a tongue. Yes, they are 11. The proposed hours are 11 a.m. to 9 p.m.
Thank you very much. Second Chair, another question which I have is that Mr. McCann in his presentation said that we won't have any glass as a mitigation for the objection which was raised for the danger of broken glass on the promenade or on the beach areas. On page 24, it says that that the containers and the decanting will be toughened glass or polycarbonate, as well as card and the like. And also on the bullet point below that one, that's the second bullet point from the bottom, it says collection of glass bottles and glass and bottles. Could Mr. McCann explain what the difference is between toughened glass and glasses, please?
Yeah, sorry, Councillor, if I wasn't clear in that respect.
Yeah. Thank you, Councillor Farquhar. Councillor, Mr. McCann, go ahead.
Yes, yeah, of course. I should have explained the difference between glass in the normal sense and toughened glass. And certainly I could give you an explanation, but I suspect Lee can give you a better explanation. So I'll pass on to you, Lee, if that's okay, because obviously you do this all the time at Hove, don't you?
Thank you, Mr. Wilson. If you'd like to advise us. You're on mute.
Surely, thank you. Apologies. Surely, I think to avoid confusion, we will not be serving through the kiosks if we are granted any form of glass. I think that's actually probably the standard terminology that's been lifted from the existing licence in place, which refers to toughened glass. We will not be serving glassware in any form if we are granted this.
Okay.
I also think, sorry, Chair.
Go ahead.
Yeah, we very helpfully you as a council model conditions. So where possible, we actually cut and paste the appropriate model conditions rather than going off piece. So I suspect it might be from there as well, but hopefully Lee's explanation suffices.
Yeah, the explanation is fine, but we'll just need to make sure that the text and verbiage actually mirrors that. So as you've offered that, no glass to be sold from the kiosk, we'll need to ensure that that is in there. I don't know whether that'll have to be conditioned or how we'll deal with that. We'll make sure that that happens soon as you have clearly stated that's your requirement. Okay, thank you for that. So I don't have any questions.
Could I just have one last observation? Is
that
I think it's a great reassurance to the visitors and residents to Sandbanks is that your staff, your staff staying on for an hour after to clean up and keep an area, do the sweeps, etc. And I believe that the other kiosk is talked about 30 meters either side of the kiosk for picking up litter, not necessarily your own branded litter, but any litter. But I don't see that as a condition in the application. It's a very generous offer, but I think it should be highlighted that that's what's been offered by this particular organisation coming new to the area.
Is it in the mediation?
Sorry, Mr. McCann, through me, thank you. I think it's in the mediation statement, Councillor Farquhar, which actually stands. So to assure you it is there. Mr. McCann, if you'd like to take us to it, if you believe it's there, I believe it is. I'm sure I've seen it there.
Sorry, Chair.
You know what, Chair?
My point is it's not in the actual bundle application. It's in the mediation statement.
Yeah, which we can take across as such, because that's part of the licence. But Mr. McCann perhaps will better explain that. Mr. McCann?
Yes, Chair, it's not in this mediation statement because it wasn't actually mentioned in the representations. So what we did was actually try to address specific concerns.
I think where the confusion there is, it was in yesterday's, St George's, yes. Right, the staff had offered to litter pick, and that really, Councillor Farquhar was absolutely right, and I'm sure that Councillor Kelsey would agree. Litter is a huge problem. It looks antisocial, it causes tensions, and that offer to tidy up and stay behind for an hour. So if it isn't there, I stand corrected.
Please add it. Please add it. I don't even need to take instructions. We do it anyway. So yes.
Councillor Farquhar, are you content with that? Yep.
I am, and again, I'll just reiterate, it's a very welcome offering by the organisation. I think it will serve you well in bedding in.
Yeah, thanks very much. Thank you.
You'll be very popular with the council if we were supposed to grant, of course. Right. Okay. So thank you for that. Thank you, Councillor Farquhar, for raising that. It was really useful. And for your comments as well, Councillor Kelsey, they all add to the mix. So we now have other persons to make representations, and we have an other person. We have, I believe, the ward councillor, Councillor May Haynes, who isn't here, but there is a statement. I believe it's the statement at page 40 of our bundle. But I'll ask our clerk, Mr. Tyler, firstly, if that's the case, and secondly, to read out the statement. Thank you.
Thank you, Madam Chair, and that is correct. So Councillor Haynes is representing the last remaining other person who wishes to remain anonymous, and Councillor Haynes has submitted a short statement which reads as follows. Madam Chair, members of the subcommittee, I'm making this representation on behalf of a resident who does not wish for their name to be disclosed. Their concerns are as follows. 1. This will provoke antisocial behaviour. 2. Will result in broken glass bottles which can be trodden by adults and children with bare feet. 3. Will encourage people to drink and drive, thus needing to engage the emergency services and police. 4. Be a danger to people who have drunk too much alcohol going into the sea, hence public rescue services being called upon. 5. Cause a public nuisance. I would ask the committee to give careful consideration to these concerns raised and assess their impact to Sandbanks and the surrounding areas prior to coming to their decision. Thank you, Madam Chair.
Thank you very much. We're in the odd situation where we don't actually have a body to ask questions, but it may be an opportunity for a short statement with regard to any assurances that can be given with regard to those objections raised. So I'll firstly ask, I can't really ask the members if they have questions because there's nobody to answer them, but it may be that our applicants would like to take the opportunity to address some of those issues. So I know they have been addressed before, but I think for completeness, we do those again. Mr. McCann, if you'd like to do that, if not, I'll move on. Thank you, Mr. McCann.
Yes, just to say that the risk of antisocial behaviour, we believe we've addressed it in mediation with the police and by reducing the hours and proffering further conditions. We've discussed the concerns of broken glass, and Lee's confirmed that only polycarbonates will be used as vessels. And in terms of the concerns about swimming in the sea and the drink driving, we would submit that they're not licensing concerns, albeit they are valid concerns in a more general manner, but they're not something for licensing committee.
Indeed. I don't know if you want to add anything, Mr. Wilson.
No, I don't. Thank you.
Okay. Very succinctly put. And again, I can't really ask our licensing officer if she has any questions because there's nobody to ask. So just for completeness, I just thought that was important, an opportunity for the applicants to provide more information if they so wished. So now we will ask all parties have the opportunity to sum up. And we're going to ask the party who spoke last to go first, and that is you, Mr. McCann. So if you would like to give your summary, please.
I think, Chair, as we haven't had anybody present from the objector, I don't think I need to repeat what I've already said. So I'll just stay safe, but thank you for listening.
Okay, and I'll offer to you, Mr. Wilson, but I expect you will be the same.
I am the same indeed. Thank you very much indeed.
Thank you very much. And Mrs. Rogers, if you have anything to add with regard to summary.
No, I'm fine. Thank you very much.
Thank you very much, Mrs. Rogers. Right, OK, I'll now conclude the hearing, and at the end of the meeting, we have another hearing. So at the end of that meeting, the subcommittee will adjourn in private with the legal advisor and the clerk to deliberate. Notification of the subcommittee's decision will be provided within a period of 5 working days, beginning with the day or the last day in which the hearing was held, in accordance with the regulations, which is today. We do have to allow for bank holiday Monday, though, so just in case you've all forgotten. And the notification of decision will include information about the right of appeal as appropriate. And I'll ask Mr. Parr, our legal advisor, please, if you'd kindly advise us with regard to the right of appeal.
Yes, the right of appeal is to the Magistrates' Court, and that runs 21 days from the issue of the notice of decision.
Thank you very much. So with that said, thank you very much for everybody's contributions today and for attending. We'll now actually go on to the next meeting, but after that we'll adjourn and make our deliberations. Thank you very much for attending.
Thank you very much, Chair. Thank you all your colleagues.
Thanks, everybody.
We'll hear in due course, but everybody else, please stay in the room. But if Mr. McCann and Mr. Wilson would kindly leave, thank you very much. Goodbye.
Thank you.
Nobody scooted off, you're all there, right? Okay. Right, so are we moving on to the next, or are we stopping live stream to move on to the next? What's the order, please?
Madam Chair, we'll probably need to take an adjournment just to get the next participants into the meeting.
If we could stop live streaming, please. Thank you. Hello, everybody, and welcome back to this meeting of the Licensing Subcommittee, Thursday, 28th of April. And we move on now to second substantive, which is item 6, which is the Railway Hotel 2-Star Road, Christchurch. An application for variation of the premises licence for the Railway Hotel 2-Star Road, Christchurch, has been submitted for consideration. This matter is brought before the Licensing Subcommittee for determination. I'm going to ask everybody to introduce themselves and to state their role, and I would be very grateful if our subcommittee members could tell us their wards. So I'll start off with myself. My name is Councillor Jude Butt, and I'm Chair of the Licensing Committee and Chair of this subcommittee for the purposes of today's business. And my ward that I represent is Creekmore, Hilborn and Waterloo. Councillor Farquhar.
Councillor George Farquhar, and I represent Boscombe East and Folkestone, and I'm a panel member today.
Thank you, Councillor Farquhar. Councillor Kelsey.
Yeah, Councillor Kelsey, East Cliff and Springbourne Ward, member of committee today.
Okay, thank you very much. So, Tanya Jardim.
Yes, Tanya Jardim, licensing officer,
Thank you
who dealt with this application.
Thank you very much. Mary Almeida.
Good morning, Mary Almeida, legal advisor to the subcommittee today.
Yeah, Mr. Tyler, if you'd like to reintroduce yourself.
Morning, Chair. Thank you. Yes, Joseph Tyler, Democratic Services Officer and Clerk for this meeting. Thank you.
Thank you. Mr. Ewan McGregor.
Good morning. My name is Ewan McGregor and I represent the applicant.
Thank you very much. And Mr. Austin Greenfield.
Hello, good morning. I'm Austin Greenfield and I'm the DPS of the Railway Hotel in Christchurch.
Thank you. And Mr. David O'Sullivan.
I'm Mr. David O'Sullivan. I'm resident next door to the Railway Inn.
Thank you very much, Mr. O'Sullivan. And in addition to everybody here present today, Democratic Services officers are providing technical support, but they won't take any part in the meeting. So just to check that everybody who's given notice for their intention to speak has been identified, and that anybody who wishes to withdraw representation or doesn't want to speak, speak now or wave your hand at me. Nope, I'm not seeing anything, so we're all content. So I'll just go through the proposed procedure for order of speaking for the hearing today, and the licensing officer will present her report. The applicant will make their application, and questions of the applicant by all parties will then be put to members of the subcommittee. Will go first. Other persons will make their representations, and questions of those other persons will then be put forward by everybody, and the members of the committee will go first. All parties will then be given an opportunity to sum up, with the party who spoke last to go first, and the hearing will conclude. The subcommittee will deliberate in private with our legal advisor and our clerk. Notification of subcommittee's decision will be given within the period of 5 working days, beginning with the day or the last day on which the hearing was held in accordance with the regulations, and that's today. So we will allow an extra day because we are bank holiday Monday next week. The notification decision will include information about the right of appeal as appropriate. So I'll just ask everybody now to confirm that you're content with that procedural process. Mrs. Jardim, are you content?
Yes, I am.
Thank you. And Mrs. Almeida?
Yes, I'm content, Chair.
Thank you. Mr. McGregor?
Yes, I'm content with that
Thank
process.
you. Mr. Greenfield?
Yes, I'm content with that.
Thank you very much. And Mr. O'Sullivan?
Yes, I'm content.
Thank you very much, Mr. O'Sullivan. So finally, I'd just like to remind all parties speaking not to repeat the information you've already submitted in writing, but to expand on that written submission. And all questions through the chairman, please. I will control the meeting, and no cross-examination of parties. So with that said, we'll move to our licensing officer and we'll ask her to present her report, please. Thank you, Mrs. Jardim.
Thank you, Madam Chair. The matter before you today is to consider an application to vary the premises licence at the Railway Hotel. This is situated at 2-Star Road in Christchurch. The application was submitted by TLT Solicitors on behalf of Punch Taverns Limited on the 4th of March 2022. The application made is to vary the licence plan to include the use of a bar servery within the existing garden. No variation to the provision of licensable activities or permitted hours has been proposed as part of this application.
The licensing office received 14 representations against the application from other persons on the grounds that the application would undermine the prevention of crime and disorder, prevention of public nuisance, public safety and the protection of children from harm licensing objectives. And mediation took place between the applicant solicitor and Dorset Police, and also environmental health, and conditions were agreed and are listed in the report and at Appendix 5. What I would just like to bring to your attention is there are some minor typos or typing errors on 2 of the conditions that do not seem to read well due to having the unnecessary words. However, should the licence be granted, they will be amended accordingly, but I will just wanted to bring them to your attention and refer members to the last condition of the proposed by Dorset Police. It states, whenever there are customers in the external area, a sufficient number of staff members, which will be determined on a risk assessment basis, to operate, monitor and supervise. It should read to operate, monitor and supervise. I merely copied from the emails that I received, so it's just clarifying those points. And also the last condition proposed by the environmental health officer, it says no noise generated on the premises or by its associated plant or equipment shall which gives rise to a nuisance. So there's 2 words in there that don't make sense. It's just to say that it's no noise generated on the premises or by its associated plant or equipment shall give rise to a nuisance. I hope that clarifies those points. We received no representations from any other responsible authorities and received 25 representations in support of the application. A meeting for the residents and the applicant's agent, Mr. McGregor, and myself took place on the 19th of April, where the main concerns expressed related to the garden and how residents believed it had been extended in the past year or so. However, they were advised that such concerns were outside of the licensing regime and ought to be referred to planning because the plan, as per the licence, remained the same. It was also pointed out that the plan provided by the applicant was inaccurate in that it looked like it went onto the middle of Stour Road. Mr. McGregor agreed that he would update, resubmit an amended plan to remove that section that covers Stour Road. Residents also queried the fact that the licence allowed for live and recorded music indoors only until 1 a.m. in the morning. However, the conditions proposed or agreed with the responsible authorities refer to music outside to stop at 22:30 or 2300 hours. It was clarified to the residents that further to the introduction of the Live Music Act, live music is not licensable between the hours of 8 a.m. and 2300 hours in a premises that holds a premises licence. Following the meeting, Mr. McGregor provided an amended plan, which was circulated by all residents who made representations. Further comments were made with regards to that plan, and that's also part of the supplementary documents provided to the report. So members are now asked to consider whether to grant this application, and should the licence be granted and the applicants fail to operate in accordance with their licence and any conditions attached to it, they will be aware that any responsible authorities or interested parties may request a review of the licence at any time. Thank you.
Thank you very much, Mrs. Jardim. So members, any questions on point of fact for Mrs. Jardim? I feel there may be. Councillor Kelsey. Yes, thank you, Councillor Kelsey.
Yeah, thank you. Thank you, Tanya. Have you had any previous complaints regarding these premises?
So they're looking at our records relating to the premises from the licensing point of view. There was one concern sometime last year, but there was no police investigating. There was nothing to say that it was relating to the premises itself. I understand that environmental health had the odd complaint with regards to noise, which again, I think is referred in one of the representations. I think it might be Mr. Cook, and the event that police got involved as well was referred to by Mr. Cook's representation. But other than that, I could not find anything else.
Thank you, Tanya.
No problem.
Thank you very much. Anything further, Councillor Kelsey?
No, I'm fine at the moment. Thank you, Chair.
Mr. Farquhar, anything on points of fact with regard to the very expansive report we've had from Mrs. Jardine with regard to information provided?
Certainly, Chair. Could we have a specific drawing or plan indicated to us in the pack which actually defines the boundaries of the licensable area as they exist just now? That would be much appreciated.
Thank you, Councillor Farquhar. Do we actually have that? Was Mr. McGregor going to give it to us? He's given it to us, or is going to?
So there was the Mr. McGregor did provide. I'll find that. It's on the appendix on the
supplemental papers.
It's page 7 of the
papers.
Page 7.
Under the email correspondence regarding amended plan. So that is the new plan.
Right. Let's
showing.
Just
it doesn't show the other premises, the other properties around it, but it shows the plan of the license plan or the proposed plan.
Right. Well, look, we've got 4 here. We've got a supplement license subcommittee. We've got email discussions re-amended plan. Must be that one.
Yeah.
Page 7 of the supplementary paper.
I'll go to page 7 eventually. Oh, there is a little thing at the top. Right, lovely. So this is from. No, I've got a letter from Mr. David O'Sullivan. I haven't got a map. Are we supposed to have a map? Oh.
Yes, I have it in front of me, so let me just see if I can find the.
Well, I'm opening up. Sorry to be awkward.
It's okay.
Supplementary papers, email, discussions re-amended, Plan F. Yes?
After that, so you have the first one is an email from Mr. McGregor enclosing the plan, and then after that is the plan.
Oh yes, I see the plan. It's green and grey. I take with pink. So that is the extent now of the area. Is that correct? It's a correct plan.
That's the plan, the updated plan that's been provided. Yes.
If I may, Chair, on my page 7, I have a drawing which is from Roman surveyors about punch taverns. So what is the licensable area, and where are our points of reference? Where are our points of reference as regards the structures which are actually within that outside area?
Right, I think Councillor Farquhar's question is, we have this map, but do we have a map of any other ilk which actually shows the built form around this as to where it is? We've got a map of sort of like a plan of the actual building, but nothing which shows the built form, the character of the area.
Thank you, Chair. And there's no measurements. There's no measurements to say this is the licensable area. To this, you will not go beyond. The further drawings, etc., then there is a question mark over extension to the garden. Maybe buildings are going to disappear. Maybe an outside bar is going to be built. I am very confused as regards what is the licensable area for the sale of off license and on site drinks.
What we will do then, Councillor Farquhar, is we will ask the applicant at the appropriate time to take us through that, so that we have a full understanding of the application in front of us, because it is a little woolly around the edges, especially as we get the updated plan today. I hope that's okay with you, Mr. McGregor.
I was going to deal with all of those points, but yes, forewarned is.
Forewarned indeed. Right. Anything else?
If I may, Chair, I don't think that necessarily establishes what is the licensable area just now.
Well, it's the only way we can establish it, really, Councillor Kelsey, because this is all we have in front of us. Okay, we can ask for our officer will be able, hopefully, to confirm or otherwise, for her knowledge, and we have 2 hands up. So I will take our licensing manager first, and then I will look to our legal advisor. Thank you, Mrs. Randall.
Well, just to assist Tanya, in the bundle and in the report, you will see that the existing application and the existing plan is attached at Appendix 1, I believe.
Page 67.
Yeah. So Appendix 1 is the current licence and approved plan.
And that's
so if you scroll down.
That is of our bundle, yes, the main bundle.
Yeah. Yeah, your main
61.
bundle.
Okay, helpful. Right, so that's page 61 of our main bundle, but you can get to it with the arrows, people, quicker.
Yeah, I mean, it again, it just shows the bar and the garden area. It's not like a Google Earth picture, but that is what we would accept for a license, I'm afraid.
Right, well, I don't have that. Well, it's not, that isn't 61 of the main pack. 61 of the main pack.
67. Sorry, 67.
Oh, okay.
Sorry, Annie.
I'm being very, I apologise. 67 we have. Right, okay. Well, that's
again, it's the Roman surveyors. That is the existing plan.
Mm.
And then obviously the proposed plan has been submitted further down.
Right, well, we have what we have, so we will go on this and we will look to advice from our manager and also from our legal advisor should we so need it. Mrs. Almeida, you have us with regard to something.
Sorry, Chair. I've sought some advice and had further views on the fact that Mr. Cook, the email that was sent to him said that it was unlikely that the hearing would commence or he'd be needed to attend before 1 o'clock. And the view of my manager is that we really should give him a chance to put his representation, especially as they're so detailed. Therefore, the report is fine because that's a matter of public record. But before the applicant's case is heard, I'm asked to request a brief adjournment. I know, Chair, you're obviously keen to get this matter on and rolling, but as he said his brother is on the way, I wonder if we could allow a brief adjournment for him to attend.
Okay, I will in this case, but to be fair to the subcommittee and everybody present, it is his brother was not the objector, he was. Therefore, I was looking to whether the objector could be present or not. I was giving some leeway, but I will always be advised by my legal advisor, and I will so do. But I think we need to be clear further, A, about timings, and B, if it's the objector. If the objector is not able to be present, then the objector is saying, but John can fill in. That's all well and good if that's appropriate and we're able to accommodate, but I'll take your advice on this occasion. So it looks like we're going to have to ask for an adjournment. And my other question is Mr. Cook. I'm sure Mr. Cook's representative, who is his brother, who is Mr. Do we know his name?
Cook.
I think his brother's called Gus Cook.
Gus Cook, Mr. Gus Cook. It would be.
I
Mr.
think,
Cook.
unless he has another brother.
Yeah.
Yes, it's Mr. Augustus Cook that's going to be attending.
Yeah, okay. So I think we're clear that if it's an objector, we would expect the objector to attend. If they can't, then, you know, otherwise we're sending in substitutes. It can make it very awkward. Okay, then. So when we get to that, then we will adjourn, but let us hope that he is with us. So it's rather put me off kilter. So moving back then, we were asking our licensing officer with regard to points of fact on her report. We'd managed to ascertain the plan was a little bit woolly, but we've now found the previous plan and we have the new plan to compare it to. So if everybody's happy with that information, I'm going to go back to the actual basic report. And the basic report was at page 67. Okay, I'll go back to members. Out of that, are there any further questions, Councillor Kelsey?
No, not at this moment, Chair.
Thank you. Okay, and Councillor Farquhar?
Thank you. I think we need to move on and hopefully things become clearer during the hearing. Thank you.
Right, okay. So are there any questions of point of fact about for Mrs. Jardim, Mr. McGregor?
There are none from me, and I can save you asking Mr. Greenfield. There'll be no questions from him in relation to the report.
Mr. O'Sullivan, are there any questions on points of fact from Mrs. Jardim?
If the red-lined area on the map is a point of fact, then that's quite an important thing, and I think that's probably what Mr. Cook has got a lot to say about. Are you hearing me okay?
Yes, we can hear you.
Okay. Yeah, I mean, because it bears no relation to reality as far as I can see the red line area. I did go and see Austin this week when I received the new drawings. I think these are meant to be, and they don't really bear any relation to the shape or positioning or size of the garden. I don't really understand the difference between the size of the garden and the licensable area. That's obviously a legal definition, but the red line area there probably relates to about half the area of the garden, probably less than that. And the way it's drawn there seems to bring it over the wall into my garden. So you seem to be licensing and drawing a fair bit of pub garden all over my garden. Just to put you in the picture, 108 and 110 bar gates are all to the left of the pub there. So the toilets and the kitchen walls, which are important points in my objections, basically are sharing wall with our houses being myself and my wife, which are 108 and 110 bar gates. So to the left of the pub there, we're basically in a terrace with them. And then Mr. Cook is 106, so he's the next one over. But the drawing itself is worse than useless, really, and it's deeply alarming to me. So if it's been taken as a point of fact, then I'd be quite concerned. Also, where the external bar is drawn there, that's not where Austin tells me the bar is going to be at all.
We're in danger of hearing your submission. Really,
no, I'm not,
really useful information to share with us. So we've taken that on board, but you don't have a question specifically from Mrs. Jardim other than the map in the plan in your estimation, and clearly it looks that way is wrong. So we cannot ask Mr. Cook if he has any questions or points of fact, so we would actually be at the time where we would need to adjourn. But can we use that adjournment, please? Could I ask somebody to, I'll bring you in a minute, Councillor Kelsey, could I ask somebody please to find a definitive map that actually shows the building line on this so that we can see where that particular map is overlapping? Thank you. Councillor Kelsey?
Yeah, it looks to me like Columbus Cook is actually in the room now, Chair.
Oh, are you here? Oh, indeed. Mr. Cook. Could we still please see if we can find
Can you hear me?
Useful. Hello, Mr. Cook. You're very welcome.
Thank you.
If you'd like to make yourself comfortable and sit down, and then we'll have a chat.
Okay, my brother's here. Who,
that's absolutely fine. Your brother's going to speak on your behalf. That's absolutely fine. Not a problem. Could your brother move over a smidge so I can see all of him? He's sort of up a bit.
All of me.
Okay. You're both welcome to be here. Okay. That's lovely. Okay. Thank you. So you've obviously missed some of the proceedings, but we've got to the stage where we were going to ask questions of the report that has been put forward, whether you have any questions on points of fact. But clearly you won't have any questions on points of fact because you weren't here. But what I will do is, as we go through the proceedings, I'll ensure that you have the opportunity to ask questions as we go along. I'm just going to refer to Mrs. Almeida. Did you want to come back in? You put your hand down again.
Yes, it was just to advise you that Mr. Cook was now also in the room. Yes, just to confirm that all that's happened is that Miss Jardim has read through the report that forms part of the bundle.
Yes, so the bundle, we've read through the report which formed part of the bundle, and you'd have had access to that. But I'll allow a little leeway because it's always much more useful when the actual officer does put it forward. You do tend to get more information out of it. So we'll allow a little leeway for you as we go along if there's anything extra that you'd like to ask, as you weren't able to be here at the reading of the report. Is that suitable for you, Mr. Cooks?
Thank you.
Mr. Cooks. Okay then. So with that said then, I would be grateful though if we could arrange please a map which showed the extent of where that house is situated, please, with the other houses that sit around it, so we can see the bleed for the garden. Could somebody do that for me, please? Could I have confirmation?
It should be in your bundle. It's a drawing S4 produced by Mr. Clumber Cook.
No, we don't have that. I'm just asking for a definitive map. Thank you, Mr. Cook, for your assistance. Is somebody there, Mr. Tyler?
Tanya's looking at that now with the applicant.
That's absolutely super. Thank you very much. Thank you for your assistance, Mr. Cook, but I just want something definitive, okay, which was specifically requested. So moving on then, and you're very welcome, Mr. Cook. We then ask our applicant on behalf of the Railway Hotel, Mr. Ewan McGregor, if you want to forward your submission, and you have the floor.
Thank you very much, Councillor Butt. My name is Ewan McGregor, as I said earlier. I am from TLT and I represent the applicant, who are Punch Taverns Limited. They are the holder of the premises licence and have held the premises licence at the Railway Hotel since conversion back in 2005. And also on the call you have Austin Greenfield, who introduced himself earlier. He is the DPS. He's been in the trade for 7 years and took over these premises about 2 years ago. So just as we were about to enter lockdown. Can I just thank your officer, Tanya Jardim, for her help and for the extensive report that appears from page 43 onwards and the papers that you've got. And there were some additional papers that were submitted by myself and also by residents, both those in favour and those who opposed the application. And I think there are 16 or 17 pages, and I will refer to those as we go along. And I will deal with the issue of the plan, which I was going to do anyway, but has become a clearly a point of contention. But just to summarise the application, and that appears at page 43 of your report, the executive summary. It is an application to vary plans to include a bar servery within the external area, and that is in keeping with what many operators across the country have been doing post-COVID and since the hospitality sector has been able to reopen. And there are a number of comments that have been made in the letters of representation from residents that do not attend to the issue that you are being asked to consider. So what I'm going to do is focus on the application. It's not a review of the licence, and the only matter that you're being asked to consider is the installation of a bar in the garden of long-established licensed premises. That's the only change, and as one of your officers said earlier, there is no intention to extend the used, and it also restricts the number of people in the external area post 11 o'clock at night. So just to bottom out the point about the plans, and if you do require, if you're kind enough to grant the application and you do require a further plan to be submitted post the application, then that is something that can be done, and it is something that is done on a not irregular basis with applications of this sort, because it's clearly important that everybody has the correct drawing. But if you go to page 69, and I apologise for this, but if you go to page 69 of your report.
Okay, 69 of the report.
And that is Appendix 2.
Mm-hmm.
And that is the existing licence.
Right.
Have we got that?
We're finding it. It's not easy because we've had some issues with access, so we're having to scroll through everything. You said page 62.
69 of your
I'm
the
just
report.
tuned in today. Page 69. Members, are we? I've got page. Is it the plan we're talking about?
No, it's Appendix 2, and it's the premises licence, which appears at page 69.
Thank you very much. We now have that. Yes, thank you. And Councillor Kelsey and Farquhar, you have that in front of you? Yep, they're happy. Okay, carry on.
So that's the existing premises licence. And then if you move forward to page 75 of the report,
yeah,
that is the existing licence. Sorry, that is the plan that has attached to the licence for many years.
Okay.
So that is the existing layout drawing that attaches to the premises licence. Right. And if you look at that drawing, there's an area to the right which should not have been included in the drawing. It's been there for 10 or 15 years, but it extends into Stour Road. And that was a point that was picked up by Mr. Cook when he made his representation.
Indeed.
So as a consequence of that, following the mediation call that we had just over a week ago, I submitted a revised drawing, and that appears, and apologies for jumping around, and that appears at page 7 of the supplementary papers.
Yep, we have that.
Which you've got that. And if you compare page 7 to page 75, it essentially takes out a triangle which runs, which was the part of the premises that or part of the license plan that had extended incorrectly into Stour Road.
Indeed. Yes.
So now what you have is a line that runs down. It's a continuation of the line of the external wall of the pub that runs down the side of Stour Road. And the intention is to stick the external bar, if you're looking at page 7, is where the R and the N are of external. And those are the former toilet blocks that sat in the garden of the pub. And that is where we wish to install the external bar.
Okay. Yeah.
So hopefully that is clear for everybody.
Okay, is that clear for our subcommittee members? Yep. Thank you very much. That's extremely.
But it's not so. That's not where the bar's going.
Right. Well,
just in point of fact.
Mr. Sullivan, please. Mr. Sullivan, I couldn't hear me. I need to be very clear. So, Mr. Gregor, one moment. I need to be very clear, Mr. Sullivan. I can't take interruptions. Okay. Oh. So I'd be very grateful if you'd put your mic on mute. So if you're a little, concerned or upset and you make a remark, that's fine. But the hearing. It's very kind of you, Mr. Sullivan. Thank you, Mr. McGregor. If you'd like to continue.
Apologies. Yes. So what I can say, and what is not in doubt, is that any external bar will be limited to what is the former loos that were in the garden of the pub. And if you require us to submit a revised drawing to show that, if you're kind enough to grant the application, then I can give that undertaking to do so. And you can also add a condition to the licence that the external bar in the garden will be limited to the former WC block in the garden.
Thank you. Can you make a note of that, please, Mr. Tarley, with regard to an offered condition? Thank you.
And also the offer to provide a revised plan.
Indeed. Like to continue, thank you.
Yes. So the application has clearly it's drawn a number of representations, and those appear in your report. Those opposing the application at page 79. I'm not going to take you through all of them. You'll have read them, and you will be aware of the issues. And some of the issues that are raised fall outside of the consideration that you're being asked to look at today. And I don't propose to get drawn into a debate about that. And perhaps more unusually, there are 25. If licensing was a numbers game, the number of representations in support of the application outweigh the representations that oppose the application. It's not just a numbers game, but it gives you a sense of where the local feeling is. And there are 25 letters in support of the application, and those appear at page 104 of your report. The intention is, and this is all you're being asked to consider today, is the installation of a bar in the former WC block in the garden. That is the extent of it. It's not going to extend into the garage. And as I've said, if you want a condition that the external bar will be limited to the former WC block, then I'm happy for that condition to be added onto the licence. And there will be a small range of alcoholic and non-alcoholic drinks that will be made available. And we have, as part of the consultation process with the environmental health officer and the police, we have mediated a position with both of the responsible authorities that have engaged in the application. And I'm not going to read each and every word of them because your officer has already highlighted those. But just to pick up on a few points that have been raised is that as a consequence of the application is granted, CCTV in fact has already been extended in the garden. And so there are now 5 cameras in the garden, whereas previously there were 2. And that system will continually record. The condition there appears at the bottom of page 45 of your report. And then the police have asked for an additional condition. This is one of the benefits of having an external bar, is that it provides greater supervision within the external area. And let us be under no illusion is that people can use that garden at the moment until 1 o'clock in the morning. So there's no restriction on when that garden can be used. And so the installation of the bar in the garden is not going to drive people to the garden, because that's a facility that the pub already enjoys and indeed can be used at the present time. But we've also agreed to a condition with the police that when there are customers in the external area, a sufficient number of staff will monitor and supervise the area for customer behaviour and to monitor noise levels. And that is a condition that does not currently appear on the premises licence. So a further additional restriction and hopefully will provide the local residents with some assurance. In relation to the environmental health officer, a series of conditions have been agreed, and your officer's already made a reference to the Live Music Act, and I'm not going to take that any further, because actually it doesn't attend to this application. But what the environmental health officer has said is that the outside bar will close at 22:30. We had suggested an hour of 2300 hours, but we are happy to agree a condition that the external bar will close at 22:30, that the garden will be empty of customers at 2300 hours. Again, a restriction that doesn't currently appear on the licence. And there is an exception to that, is that beyond 2300 hours, the number of people in the garden should be limited to 8 people, for those people who might want to nip out and have a cigarette or might want to make a phone call. So all of those restrictions not currently on the licence. And then there is an additional requirement in relation to the provision of a noise management plan. And that is a discussion that has happened and will be an ongoing discussion with the environmental health officer. So clearly, in the granting of the application, it will provide benefits over and above the conditions that currently attach to the licence. It will provide greater supervision of the external area, and it will also assist with customer flow within the premises. And we have made a significant number of applications across the country for external bars, and it's something that has happened. It's one of the consequences of COVID and the lockdown that happened last year, is hospitality businesses try and resurrect their businesses post the lockdown. And you'll be familiar, not only being an authority area which probably relies very heavily on tourism and hospitality, but the broader impact that COVID has had on the hospitality industry. Now, so far as the residents are concerned, I'm not going to take you into everything that they've said, because in my mind this is a relatively straightforward application, and it is a restricted application, and in fact it benefits the residents because of the additional restrictions that are added to the licence. But it may be that some of the residents misunderstood what the application was about, because a letter was circulated to local residents. I don't know who circulated that letter. I don't have any objection in the local community being engaged in these applications, because of course it's important that they are. But that letter appears at page 5 of your additional bundle. And it may be that there was a misunderstanding as a consequence of what was said in that letter as to what it is that we were looking to do. But actually,
can you take it? Sorry, Mr. McGregor, page 5 of our bundle, we got 4 extra bundles. So which?
Sorry, it's page 5 of the additional bundle of papers.
Yeah, well, we have 4 additional bundles. We've got supplementaries for licensing subcommittee. We've got email discussions. We've got.
It's a document that says additional info solicitor, supplementary paper, additional info solicitor.
No, I don't have that. And you're saying this is in the supplementary
bundle. It appears at page 5.
Okay, well, I'll take your word for it. Joe, Mr. Tyler, you sent all the supplementary bundles, didn't you? There were 4, I believe.
I can share if I'm able to share my screen, then I can show you what the.
Yes, if you're making reference to something, I think it's only fair that subcommittees are able to see that, but we're not able to find that with the reference you're giving. So I'd be grateful. Unless Mr. Tyler, you can find it for us. It's just that we don't have any of those.
Can you see that?
We can indeed. Yes, I can see that.
So this is the letter that's been sent. I'm not going to take you through it.
Fine. Yes, I've read it.
But it says.
I have read it. Yes, it's fine. Yeah, I've read it.
Fine. Okay, well, I'll stop sharing then. So as long as it's just important that you know the point of reference. So at the end of the consultation period, when we'd agreed a position with the environmental health officer and the police, we offered to host, as your officer has said, a mediation meeting with local residents to explain what the position was and to provide some legal background to the application and what is and is not permitted in the garden. And can I just make a number of observations as to what the residents say? Regardless of whether or not there is a bar in the garden, at the present time, the garden can be used for consumption. And if the application is refused, it can be used until 1 o'clock in the morning. If you grant the application and permit the use of the garden, the bar in the garden, then the conditions attached to the licence protect the position of the residents and the garden will be cleared by 2300 hours, save for those 8 individuals, up to 8 individuals who might want to nip out for cigarettes. And so if there are concerns about the way in which the premises has or may operate, it is perhaps not unreasonable if you look at the comments that are contained in the letters of the residents who oppose the application, it's perhaps not unreasonable to assume that the police and the environmental health officer would have opposed the application, but they haven't opposed the application and they have agreed to conditions being attached to the licence. And I think it was Councillor Farquhar said in the previous application that, and I absolutely agree with him, is that the police and the environmental health officer and the other responsible authorities are there to protect the interests and amenity of local residents. That's one of their functions. But they've agreed conditions with ourselves and with the DPS Austin Greenfield. And just I'm not going to take you to loads of policy and loads of guidance, but just to highlight one point in relation to national guidance, that's at 9.12. Of the section 182 guidance, and it appears, it's not before you, but your legal officer will be familiar with it. It appears at page 70 of the national guidance. And it says that each responsible authority will be an expert in their respective field. In some cases, it is likely that a particular responsible authority will be the licensing authority's main source of advice in relation to a particular licensing objective. The police have a key role in managing the nighttime economy. The police should usually therefore be the licensing authority's main source of advice on matters relating to the promotion of crime and disorder licensing objective. And so it follows through that the environmental health officer will be the main source of advice in relation to the licensing objective of public nuisance. It's always dangerous for an advocate who's representing a pub to invite a review of the licence, but as you made clear, or one of your officers made clear when they were reporting to the committee, if there are issues with this pub, then it is open to anybody to review the premises licence, and that is whether you're a ward councillor, whether you're a local resident, whether you're somebody who's affected by the pub, whether you're the police and the environmental health officer. And that's not what you are here to consider. And I apologise for labouring the point, but it's just that a number of issues have been raised in the letters of representation which don't attend to this application. All you're being asked to consider is an application to install a small bar in the external area of an existing licensed area of the premises, which can at the moment be used until 1 o'clock in the morning, but which use will be restricted until 11 o'clock in the evening. And there are further additional conditions. And so standing back from this, the position of the local residents, the local community, and you as a licensing committee, and indeed the responsible authorities, is better protected if this application were granted than if it were not. And that's all I have to say.
Thank you very much, Mr. McGregor. Mr. Greenfield, did you have anything to add? Don't feel you have to, but
nothing to add, thank you.
You're content, right? Thank you. Okay. So now it's an opportunity for questions of the applicant by all parties, and I will start with the members. Councillor Kelsey.
Thanks, Chair. I don't really have any at the moment. I'm just glad to see that mediation has taken place, and I do agree with what Mr. McGregor's saying, that the revision of the conditions on this license do actually make it far easier for the resident. With it being licensed to 1 o'clock, they had virtually no say whatsoever. But now that they've offered the conditions for the 10:30, I think it's a much better idea, and residents should feel safer with that in place.
Yes, a very, very good point. Thank you, Councillor Kelsey. Councillor Farquhar?
Thank you, Chair. Just the one question of clarification, which I'll come to. But if I may, McGregor said that the garden would be cleared by 2300 hours, save for the up to 8 people that may be in that area for smoking, etc. Can Mr. McGregor or somebody point to me in the variation of the license where that's actually stipulated, please?
Yes, Councillor Farquhar, if you go to page 46 of the report.
It's under the environment. Yeah, it's under the environmental health agreed conditions.
It is, and at page 46 of the report, the outside bar will be closed at 22:30. The garden will be empty of customers at 2300. Patrons are permitted to temporarily use the garden after 2300, e.g. to smoke or make a phone call, but shall not be permitted to take drinks or glass containers with them. This shall be limited to a maximum of 8 persons at any one time.
Saying, just wanted to confirm that I hadn't read that and that I couldn't find it.
There's a lot of paper in this, so it's yes, I don't.
Absolutely, I agree with Councillor. It actually makes it to ensure that the licensing objectives are upheld, and I appreciate the mediation that's going on. Just for clarification, because it did come up as a point, if I may, Chair, if we go to the supplemental bundle, page 3, where we're looking at photographs of the there we go, where we the photographs of the pub as it existed in 21 and as it exists now. And
are we talking? Sorry, Councillor Farquhar, we have 4 packs of supplemental. So which pack?
In your,
if you want me to share, I think I know the photos that.
This is the difficulty when it's very difficult for our admin staff. They try and put a heading which makes sense to us, and then somebody else uses another heading and nobody can find it. So if you can share, that would be useful.
if I may, Chair, the
is
photo you're looking for on the rear of the pub. Oh, let's have a look.
Right, we'll find that then.
Yes, that's the one. The rear of the pub, 2022.
Yeah.
Is it possible to zoom in at all?
Well, we can find. I found it now. It's actually in the first bundle.
Fine.
Thank you, Councillor Farquhar. It's in the first bundle of supplementary papers, and it's page 4, I believe. Is that helpful?
So, what? It's just for my clarification and perhaps for the confusion which we had, because just to clarify with Mr. McGregor, is to my understanding of the presentation is that the building which we see to the right that has the lamp above the lintel is what was formerly the garage.
That's right.
Is that correct?
If I can, Councillor Farquhar, can I just pause there? And the sad thing about the remote hearings is I haven't had an opportunity to come and visit the pub. But if I've got any of this wrong, then Austin will jump in and correct me.
That's fine. Yes, carry on.
Thank you. So the area to the left of that sloping roof garage used to be a smoking shelter, and that used to be the rear of the garden.
Yep.
Now, in your presentation and the confirmation of the reassurance of where it would be, is where the mouse is sat just now. Whoop, that's it. If you look through the open door of the garage, which has the lamp above it, you have the open doors, the open where the mouse is actually at that crosshair. That was the site of the WC, and that is the proposed site within the confines of that, what you see where the outside bar is proposed to be established. Is that correct?
That is correct. And if you or I have got that wrong, then Austin will jump in. But Austin, can you just confirm that's right? And where my cursor crosses is that that is the problem.
I'll ask Mr. Austin if you'd like to do that. Thank you, Mr. Austin.
Sorry.
We need a clarification as to whether the extent is just within the old WCs there. Thank you.
Yes, that's everything you said is correct. Yes.
And
Right.
the last point, if I may, Chair, the last point of clarification is that where that mouse was, where the bar will be, that is the boundary fence to the immediate neighbours, or the boundary to the immediate neighbour's garden. Is that correct?
Mr. Austin?
Yes, that's correct.
Okay.
Thank you, Chair. No further questions
Thank you
this
for that
time.
clarification. That was useful. Thank you.
Can I
and
stop sharing this photograph now?
Yes, you may, Mr. McGregor. Thank you very much. We have indeed found it. It's just when we've got lots and lots of extras, we do want to find it to be sure that we've got the right reference. Thank you very much. Thank you, Councillor Farquhar. So now it's an opportunity for other parties to question the applicant. So I'm going to ask Mr. Augustine Cook if he has any questions for the applicant. Thank you.
We don't have any questions.
And Mr. Cook, I'll be clear. This isn't your opportunity to give your submission. That will come. This is for you to ask questions on what you've heard. You've still got the opportunity to put your full submission forward in a short while. Okay?
Thank you. I'm at a bit of disadvantage because I haven't seen the bundle and I don't know exactly what pages are being referred to. So I apologise if I can't refer to specific pages. As far as what the applicant has said so far, I don't need any further clarification of that.
Okay, Mr. Cook, thank you very much for that. And Mr. O'Sullivan, did you have any questions for the applicant? Again, you have your opportunity to make your full submission in just a moment.
Only the question that Mr. McGregor, does Mr. McGregor believe that the new drawing, that he was quite concerned with a triangle of licensable area that was on Stour Road, which I gather is just a mistake and obviously bears no concern to me, has gone. But does he now believe that the new drawing to be correct? Or is he under that impression in terms of the licensable area?
The only change to the plan is the removal of the area from Stour Road,
right?
The red line will be the extent of the area within which licensable activities can be provided.
But that doesn't need to bear any relationship to the size of the actual beer garden. Is that the case?
Well, I think we're straying into, and Chair, this is a point that I didn't want to get drawn on, because when we had our mediation meeting, I explained to the residents about consumption not being a licensable activity, but the areas within the red line are the areas within which licensable activities will be provided.
And you can raise further issue with regard to your submission. You'll have every opportunity, Mr. Sullivan, okay? As things go on and more information comes to light, more understanding of the situation, we'll make sure that you can cross-track back, okay?
Thank you very much.
You're welcome. Okay, so if everybody's content with their questions, Mrs. Jardim, do you have any questions for the applicant?
I don't, thank you.
Thank you very much. Okay. So now it's the opportunity for other persons who in this case are objectors. Mr. Sharp is not there, he was a supporter. So we've got Mr. Augustine Cook. So it's your opportunity now. We'll just find your reference that you sent in, and it is page, I think it was page 40, was it, of the public report? Quite a long, may have been further. Some assistance as to page numbers here, because we don't have any bookmarks. I would be grateful as to where Mr. Cook's objection sits. What number was it? 20 something? I think I've just gone past it.
It's page 86 of your bundle.
You're very kind. I just actually got there. Lovely. So page 86 of the bundle, and this is the representation with regard to Mr. Cook Representation, yes, objecting. So, Mr. Cook, we've got the information in front of us, and the floor is yours. Thank you.
Thank you very much. Have you also got a plan that looks like this?
We don't know because we can't see it.
All right.
I believe we have. Yes, I believe it's in the bundle. Yes, thank you.
Okay, sorry, I can't refer to it because I haven't got the bundle. So, all right. Okay. So, Mr. Cook, Mr. Columba Cook, lives 9 metres away from the side wall of this pub, and he's been asked to speak for a number of local residents. Their concerns are that for the past year, since April 2021, when the railway reopened, they've found themselves living really unbearably close to what appears to have become an open-air party pub. They have their own lived experience of having to suffer this intolerable noise nuisance and unacceptable criminal behaviour coming out of the railway. So they're not speculating about what might happen in the future. They are just concerned that any action, particularly a variation of the licence to facilitate the dispensing of additional quantities of alcohol to additional numbers of people, is just going to make matters eminently worse. There's a significant amount of evidence in support that's been presented by Mr. Columba Cook and the other residents, including clear and accurate plans and photographs which depict the actual size of the area involved. If there is any doubt whatsoever about the plans, I would strongly invite the councillors to adjourn and come and have a look at the site to see what's actually involved and how close everything is, because it would seem unreasonable and unfair to make a decision when there's any uncertainty whatsoever about the areas that are really involved in this case. There's video evidence which can't be aired publicly, in one case because of fear of a resident of being identified and having repercussions. And there's Mr. Columba Cook's own video evidence of a physical assault, which shows perpetrators' faces and raises concerns for BCP about GDPR, etc. But the attack is clearly written in his written submissions, and I'd strongly urge the committee to have a look at that. So we have a bad situation where some residents remain or wish to remain anonymous for fear of reprisals, and details of this have already been provided to Tanya Jadim. The central problem is the creation of what is in effect an open-air party pub in the heart of a residential area with over 103 separate residences within 100 metres being adversely affected. And the addition of an external bar will simply make the problem infinitely worse. The clear purpose is to facilitate the provision of greater quantities of alcohol. There was a phrase used of it will improve customer flow. Well, they're advertising, garden events for up to 120 extra people. If you consider 120 extra people being in this pub, and you look at the original floor area of this pub, you're talking about 2.5 times bigger than it is at the present time, for toilet facilities which are probably inadequate to cope with just the floor area of the internal size of the pub. The problem is that this external bar will just facilitate the provision of greater quantities of alcohol to greater numbers of customers, which will in turn create greater noise nuisance and increase criminal behaviour. The residents have complained to the operator and the applicant over the past year, and their experience is really a callous disregard of anything that they have to endure, and a continued plan to develop this open-air party pub in the future. The process that has got us here today, the residents complain, is flawed because the proposed conditions agreed between Environmental Health, the police and the applicant were finalised before the end of the consultation period, and as such they could not have taken into account the public representations which were collated towards the end of that period. Just one example is that the Environmental Health Officer was unable to take into account residents' complaints and fears of the nuisance caused by live streaming, for example, of sports events. And his reply to residents was, "I'm sorry, that moment has passed. I've already agreed the conditions." Secondly, that the plan that accompanies the application is inaccurate and it doesn't really show the true extent of what will happen in this pub. I appreciate that Mr. McGregor says that he can split hairs and say this is where alcohol is being provided and this is where it is being consumed. But what we're talking about is the overall effect on the noise nuisance and the capacity of this pub to bring in an extra 120 people. Coming up with a plan at the 11th hour is again part of what I say is a flawed process, and the plan still being inaccurate, and an offer of a further plan is after the event, after a decision might have been made, is again a flawed process. So whatever happens, I would urge the committee to look very, very carefully at the plans and what is proposed and what is consequently being facilitated here. And as I say, I would invite them, if there is any doubt whatsoever, to adjourn and come and see exactly what's going on here. The operator would like to suggest to you that this is just an innocuous small bar in an existing licensed garden. Of course, the garden is, of course, a lot bigger than it was pre-COVID, has already been pointed out by the councillor who referred to those photographs. In fact, the bar extends the licensable area into an external WC block, and the ramification is that alcohol and food will then be taken to parts of the garden area and what was previously the car park, which is well outside the licensable area. Again, filling it up with people who will produce noise. The present licence states that the performance of live music will take place indoors and the playing of recorded music will also take place indoors, not in an outside open air pub. The residents would like reassurance that this will not happen outside in the garden. The tighter restrictions which are being suggested are no consolation to the local residents who cannot enjoy their homes and gardens. They cannot sleep, their children are disturbed, and they have met with a remark that, well, it doesn't matter because under the Live Music Act we can do it anyway. If that's so, then the licensing condition would appear to be pointless. If not so, and the condition overrides the Live Music Act, then in this particular case, given the problems that have been experienced over the last 12 months, the condition should be extended to further prohibit external live music and recorded music at all times, which would actually be in line with the current licence objective to keep the live and recorded music indoors. With regard to the proposed conditions, looking at those for a moment, as far as the police conditions are concerned in the provision of CCTV, CCTV does not record noise levels, so it's not going to provide any consolation to anybody. The fact that there is a bit of CCTV around, the CCTV is not going to pick up all the male customers who regularly go outside and urinate up and down the wall in Stour Road, because an extra 120 people can't get into the few toilets that there are in the pub itself at the moment. So we don't know what could possibly control or provide effective control of the noise nuisance that's been suffered for the last year. It is possible for a dedicated sound monitoring system to be installed and activated at predetermined sound levels with a data recorder. This is something which Mr. Cook has occasionally had to employ for public buildings in the course of his career as an architect. So it is possible for such a condition to be added. But otherwise, I don't see how the condition that the activities on the premises must not cause a nuisance can ever be effectively monitored. Looking at the situation, the safety situation immediately outside the door, the gate of the pub, nothing less than really independent security provided on the gates. And if they want CCTV on the outside wall, is going to provide any effective control of people fighting, arguing, urinating up against the outside wall of the pub in Stour Road. As far as the environmental health conditions are concerned, no amplified music after. I'm sorry, if I correct me, was it 2300 hours? Is it, or 2230?
2230.
2230. Bearing in mind that the number of residences within 100 metres of the pub is 103 in total, and we've got children, we've got elderly, we've got sick. These people, it's not an optional extra to get a good night's sleep. It's essential. So if you're minded to allow any sort of amplified music outside, I would submit that it should finish a lot sooner than 2230. As far as condition 2 is concerned, the clearing of the bar and the garden emptied at 2300 hours, again, to turn out 120 people onto the street at that time of night is inevitably going to cause noise disturbance. The garden itself can remain open till 1 o'clock in the morning for a maximum of 8 people smoking or phone calls. Well, that sounds that sounds reasonable, but the residents that I'm speaking for are obviously very concerned as to how on earth this condition will be effectively policed and numbers kept to 8, and there won't be just continual noise going on in the garden well after that time. Over the past year, they've had experience of lock-ins and staff parties in the garden going on well into the night, long past these times. So particularly concerned about that. The final condition about the requirement of a noise management plan, it's not clear whether this is something that has to be provided on for each and every event, or whether it's just going to happen once and then nobody's going to know about it. Residents are also concerned about how they are going to be effectively involved in how these noise management plans are put together. The noise management plan is so that there would be no public nuisance caused in the area, but obviously an open air party pub is almost by definition going to cause this nuisance in the area. So what's going to happen when this condition is inevitably breached? Do we all have to come back and ask for a review of the licence condition? Because it's obviously going to happen. So the neighbours' concerns are really centred on the question of public nuisance, and you have instances of noise nuisance, evidence of the noise nuisance. The fact that the business model of the pub is to turn it into a party pub. The live streaming of sports events, and we've got the FA Cup final, the Champions League coming up in the not too distant future. We've got amplified music, we've got karaoke. I sat here in the summer last year and was subjected to very loud, noisy, lewd jokes from someone at a microphone in the garden. And that was broadcast all over the area, and you could actually hear the disgusting language and the lewd jokes. It's not, as I say, it's not something that the residents are speculating about what might happen in the future. It's what they've actually experienced so far. They've also experienced the crime and disorder, the fights, the violence, the criminal damage, the urinating outside, and hygiene and health and safety. There's the vomit, the broken glass, the bottles, the waste on the footpaths on the road outside. All of these things the residents see as just a chance to be made worse and facilitated by the provision of an extra open air licensed bar in the open air part of this pub. I would mention that the ward councillor, Peter Hall, actually supports the residents' objections to this application. I don't know whether that's got through. The residents would obviously like to see an appreciation by the environmental health officer and the committee of exactly what the residents have had to suffer over the last year, and are likely to suffer in the future as the railway develops into this open air party pub. If the variation is granted, they would like to see adequate conditions applied to the licence to reflect an appreciation of the extent of the problems that they will otherwise have to endure. They would like to see effective controls to prevent any nuisance of any kind that has occurred over the last year. They would like the pub garden to be reinstated to its pre-COVID and licence plan dimensions and not have this extended part right into the car park, which you could see on the photographs in front of the garage block that was there to the right. And they would like to see no amplified music or live streaming of any sort in the garden, and that all this noise is kept indoors as was originally envisaged by the licence, and ideally they really object to an external bar, which they just see as making matters much, much worse. Thank you.
Thank you, Mr. Cook. Lot in that, and I think first I'm going to ask in a moment for the licence officer to come in and give us some advice well, not advice, but just to confirm the present rights of the applicant with regard to their licence. But you touched on a lot of very concerning things there, talking about noise, crime and disorder, hygiene, health and safety, vomit, etc., etc., etc. And you asked the question, can the licence be reviewed at any time should that conduct be occurring? The answer is yes. There are 4 general duties of licensing authorities within the licensing objectives, and they are the prevention of crime and disorder, public safety, the prevention of public nuisance and protection of children from harm. So your submission seems to be telling us that all those things are happening. So you do have the opportunity, should you so wish, to request a review with regard to this premises, and then that would be dealt with accordingly. It's not a matter for today, but it's just that you did seem to be quite upset about that, and you do have rights, and I was advising you of them. So I just wanted to go now to Mrs. Jardine, if I may, and to ask her, lots in there, but could you please take us through, for confirmation, what licensable activities are allowed now, and what is the extent of the variation in comparison? Because there's lots and lots of things which can actually go on now, which I think Mr. Cook feels are actually extras. So I do think we need some confirmation there and some clarification. Thank you, Mrs. Jardim. I hope that question is clear.
So just to clarify, so just to go through what they are currently licensed for, yes, and what the application would change. Is that correct?
Yes, that'd be lovely.
Okay, no problem. Just bear me 2 minutes. I want to open the current licence so that I can read through it. Okay, so currently they are and they have live music Monday to Saturday, 10 AM to 1 AM, and Sunday, 10 AM to midnight. And they have a further hour into the morning following every Friday, Saturday and Sunday and Monday for each May bank holiday. spring Whitsun bank holiday and every August bank holiday weekend. And a further additional hour into the morning following every Thursday, Friday, Saturday, Sunday and Monday for the Easter bank holiday weekend. As well, an additional hour for every Christmas Eve and Boxing Day. Recorded music is the same hours as the live music, and they have, as already mentioned, and supply of alcohol Monday to Saturday, same hours, and Sunday 10 a.m. to 1 a.m. and Sunday 10 a.m. to midnight. And again, the non-standard timings are the same with regards to bank holidays, Christmas and Boxing Day. At the moment, they are not applying to extend or modify any of these hours. What the application is asking for is for a bar servery at the back of the premises, so the hours remain the same. However, the extra conditions that have been provided and agreed with police is that they will stop these activities at 22:30 every day. Just to clarify, in the recorded music and live music, as per the licence, is indoors only. But as previously explained, the Live Music Act provides that exemption that it only becomes licensable between the hours of 2300 and 0800. So between the hours of 0800 and 2300 each day, the recorded music and live music is not licensable in licensed premises. Does that clarify?
Well, license is required.
Pardon?
You're saying that a license is required or that it's not allowed?
No, so between 8 a.m. and 11 p.m. It does not have to be included in the license because the Live Music Act.
Yeah, I understand that, but after that, it's a licensable activity.
Yes,
that's fine. I think we need to be clear for Mr. Cook. Obviously, we understand, but I want Mr. Cook to understand because it's extremely complex. I wanted him to understand the situation that the licensing the subcommittee are dealing with regard to the various permissions which are in train. Did you have anything else to add? That was excellently put.
The only thing I wanted to add just very quickly, I'm not sure if it's the right time to do so, is that Mr. Cook did mention and propose that these not to use the Live Music Act and reduce the hours for the regulated entertainment. However, that's not possible to do. The only way to do that is via review, I'm afraid.
Yes, there's an awful, thank you, Mrs. Jordan. There's an awful is via review. And anything which obviously is impacting upon within the 4 licensing objectives, if they are deemed to be being breached, then a review can be asked. But we can't just make changes, Mr. Cook, today. We can't say, well, we'll reduce your hours to such and such, because we need to have reason. And there's no reason. The applicants have come forward with a variation. So I hope that's given you a little bit more information with regard to the situation. I don't know if our legal advisor would like to give comment, or indeed our general manager wants to give comment. I'm happy to open the floor to them if they do. Mrs. Amaze, did you want to give any comments, or are you content with Mrs. Jardim's iterer?
Yes, Chair, I think both Ms Jardim and yourself have clarified the position well, that we're not here to review the conditions of the existing licence. We are purely looking at the effect that the additional outside bar will have on the licensing objectives.
Yes, that's very useful. That's very succinctly put. Mrs. Randall, did you have anything further to add, just to assist our objector? Because I think it's only fair that they're given as much information and understanding as possible as to the constraints and also of their rights. Mrs. Randall.
Thank you. I think Mrs. Jardim has actually very clearly stated the case, so I don't need to add anything to it. Thank you.
Okay, thank you very much. Thank you very much, Mr. Cook. And now we will go on to Mr. O'Sullivan. It's your opportunity to put your submission forward, and the floor is yours.
Thank you, Councillor Butt. Yeah, I mean, a couple of main concerns which I raised at our sort of mediation meeting last week was one particular point which is of particular concern to us living next door and having been sharing about 70 foot of garden wall with the pub and the new garden, was the point introduced, condition introduced by the environmental health officer down there, I think, and that he says no noise should be generated on the premises by its associated plant or equipment shall give rise to a nuisance. And this is a major nuisance to us in that we have, if you're looking at the plans, the incorrect plans, you'll see the kitchen wall there, and there's a very small location plan inset on the right, which gives the actual area covered by the pub at the moment with an extra triangle. Now the extractor fan from the kitchens comes out.
Mr. Sullivan,
Yeah.
let me say that. I believe you were advised that this is not relevant to the application, but I will ask for that further advice to be given. You're on mute.
Yes. Yes, so Mr. O'Sullivan did send a video this morning with the extractor fan and was advised that the extractor fan was to be dealt with via planning, if that is the issue.
Yeah, the extractor fan has no, Mr. O'Sullivan, please, if you would just tune in. The extractor fan has no bearing upon this application as far as the licensing remit is concerned. But we obviously would want to advise you that if this is an issue, please take it through the planning route. And the chair of planning is actually one of the subcommittee members today, so I'm sure he will keep an eye out for that if you so wish to raise that. You do it through the appropriate purposes through our planning services. That's BCP Planning Services. That's a concern. Please report it and it'll be dealt with. But the licensing committee do not have that remit. So if you'd like to move on, Mr. Sullivan, thank you.
The other main issue was really to do with the confusion caused, I think, generated by the plan as it's drawn, in that it appears that the licensed area, and in particular where the external bar is drawn, appears to be in our garden. Now, is there no compunction or obligation to show the actual area of the license of where the licensable activity is going to be going on, i.e. drinking, and where the actual bar is going to be, in that this shows perhaps less than half the actual area that Mr. Cook was actually drawing attention to, but also where the bar is of concern if it's going to be actually over the wall. I mean, so that's my kind of, a main issue there. I'd reiterate or support many of the concerns from Mr. Cook, and as he represents various local residents as well, that we can point to lots of nuisance activities, difficult activities. I mean, for example, vomit and so on, which is a repeated problem. And I think this, if it relates to the application thing, probably is generated from the fact that the license as it exists now extends to 1 in the morning, and that is something which apparently could go on in the garden, but in itself is an extraordinary situation for a bar in a residential area, which seems to be really out of keeping with the purpose of what the pub used to be up until 2 years ago, when the new management took over and it was revamped with the extended garden. Now it's much more of an events pub, you might say, whereas in the past, these kind of activities were very, very few and far between. Now they're regular events, and this is a pub on the way to a couple of schools, where in the morning you can have broken glass and vomit and so on. I had to draw vomit to the attention of Austin this weekend outside my front door. I mean, these things are happening all the time, and as the Cooks pointed out, that if you're going to invite an extension of the activity, then we can only expect an extension of these occurrences.
Okay, Mr. O'Sullivan. With regard to the plan, I think we do need to nail this down for your assurance. Now, we, in the supplemental McGregor, Mr. McGregor, I will ask for your support or your advice in this, your guidance. Our supplemental papers which you sent through, I think we're at page 6. That gives a picture of the rear garden. Now, that, as far as I understand it, as far as our licensing officer understands, is the extent of the licensable area, except for the bit at the back which says unauthorised extension to beer garden not included in licence plan. Now, we have the other picture from Mr. Cook, which was the odd triangular shape, which we've already discussed. It goes into Stour Road, is not the actual plan. It also encroaches into the back garden. I believe that's Mr. O'Sullivan's back garden, that odd triangular shape. Which obviously you cut the bit off on Stour Road and you cut the bit off onto the private garden of 110. Are you 110, Mr. O'Sullivan?
110 and 108.
You're 110, yeah. So that actually is it's just unfortunate, but I think it's rather I don't want to use the word erroneous, but I think we can be certain that on your I don't know if it's yours or Mr. Cook's, excuse me, but there's page 93 of a submission, I think it may be Mr. Cook's, and it shows a map, and there is this huge sort of funnel shape popped on the end of the curtilage of the building, and it shows the bleed into Stour Road. It also shows a bleed into halfway through your shed, and let me see. No, it shows a little bleed, doesn't it, into your private garden. There's a tiny little overlap, but that is not in fact the case. The actual licensable area, I just want confirmation, is that of which Mr. McGregor has sent this supplemental plan, and that's page 6 of his papers that he forwarded this morning. Yeah. Just wanted confirmation, Mr. McGregor, if I may. Thank you.
Yes, can I just clarify this? We don't. There's no intent to extend. Sorry, can you hear me? My screen froze for a second. I'm not sure.
Yep.
Yes, there's no intention to extend into Mr. O'Sullivan's garden. Clearly, the point was raised about the bleed into Stour Road. Your words, Sharon. So we've attended to that. I think sometimes people look at licensing drawings through a lens that is perhaps not.
They have to be indicative.
Yes, and so the detail perhaps on licensing drawings is perhaps not the detail that one might expect on other architectural plans, and that's just the way it is. I apologise if there's any error on my part. If I can take you to the drawing at page 11 of your supplementary papers, which is one of the drawings that Mr. Cook has submitted.
Okay, page 11 of supplementary papers. I don't have page 11 of supplementary.
Right. Well, I can share that with you if you want me
I think you're going to have to. Yeah.
Let me just see if I can find it.
Yes, the amended plan, and he goes up to page.
Right. Okay. Let me just share this with you now. Sorry, just bear with me and my lack of technical expertise.
Oh, we join you in that. We've got. I found page 11 now. It's
right.
A bunch of papers, members. If you're wondering where the far we are in this, it's page 11 of the first bundle. Yes, we found it. I think. Yep.
So we're absolutely clear. I think that Mr. O'Sullivan lives at 110, and I think that Mr. Cook lives at 108.
No, I'm 108 and 110.
Right.
Myself and my wife, we own both houses, and then Mr. Cook's 106.
Right. Okay. Thank you.
Thank you for that.
Thank you for that. And the WC block, and Mr. Greenfield will correct me if I've got this wrong, is this block here, and that is where the small external bar is going to be. And the garage, which I think Councillor Farquhar was taking us through, is that building that has the light and the flue that's coming out of the roof. So that actually is a very helpful drawing in to show where the external bar is.
That's excellent. Yes, so there's no.
But I'm not going to get drawn into an argument about whether or not the pub car park is being used for consumption, because that's not actually a matter that you're A, being asked to consider, or B, something over which you have any authority.
You'll have your opportunity in a minute, Mr. McGregor, to ask questions of.
So is it still my chance to speak, Chair? Am I still on?
Absolutely, Mr.
Oh, I'm sorry. I'm sorry that map's gone now, because I thought that was quite useful.
The
map's gone.
Mr. Sullivan, please, Mr. Sullivan, one at a time. If you could listen to the chair, I'd be grateful. Had you not finished your submission?
Well, there was a couple of other points that arose just from the previous submission.
I'll give you some latitude then. If you could be swift and make your further points, and then we'll move on.
Well, only just looking at the map that Mr. McGregor, which is quite helpful actually, because it now, if you can imagine looking at the map as was, and I believe you've got it, I don't have that benefit. The new pub garden is about double the size of the pink area as it appears on there now.
As Mr. McGregor said, and I will look to a legal advisor, if I may, Mr. O'Sullivan, please, or Mrs. Jardim, to the extent of the licensable area. We do need to consider what we can consider here today. We can't talk about semantics about other areas. So I'd be grateful for some confirmation, please, Mrs. Jardim, or legal advisor, Mrs. Almeida. Thank you.
Yes, Chair, just to confirm, we are only today concerned with the licensable area, which is not the area in pink.
I know it must be very frustrating, Mr. O'Sullivan, because you know, we'd love to wave a magic wand and sort out all these civil and tortious and planning issues, but we can't. We just have to look at the licensable area and our remit. Okay.
Does the various additional agreements, the conditions agreed with the police, and as I was trying to get confirmed, the conditions agreed with EHO, do they not form part of the new license agreement if it's awarded? As they're being presented as conditions, surely they need to be adhered to.
Right, I will ask Mrs. Jardim
is that the case?
To give the Councillor Farquhar. I'll come to you in just a moment for members' questions. Mrs. Jardim, would you be kind enough to confirm the remit of the responsible authorities with regard to any application? Thank you.
So currently, the new conditions that have been proposed, I'm not 100% sure what Mr. Sullivan was asking, but I think my understanding was that you were asking whether these will form part of the licence. Is that correct?
Not. I think what he's asking was he felt that the consultation period had not yet completed, and yet information, advice and agreements were met between one of the responsible authorities, which I believe was the police. This is Mr. O'Sullivan's understanding, so it may be that you would need to further advise. Thank you.
No, so the responsible authorities, as well as any other parties, do have up until the consultation period to make any representations. Okay. However, if they are satisfied prior to the end of the consultation period, with either by mediating conditions or any of their concerns having been met, then they may decide to make an agreement, which is what's happened in this situation. I cannot speak for Environmental Health Officer or for Dorset Police why they didn't wait until the end. As the administrator, it is merely to accept what they've given me when they have given me.
My question, Tanya, if I may, was whether these conditions, as I think Mr. McGregor actually provided them in his letter, whether they form part of the license, if the license is approved, that all these conditions will be adhered to, if you like. They become obligatory, because as they stand, the police put great store on the CCTVs, which there are CCTV cameras there, but they're not particularly helpful if the gates open all the time and the gate's actually broken so that it doesn't actually close. I had to fix it myself a couple of times. This is the garden from the gate from the street into the pub garden. So, you know, the access is there as the cameras will do no good at all. And the other thing is this idea of staff monitoring and everything, which is going to benefit us so much. There's been adverts in the window for months for staff. You can't get any staff. So where these staff are going to come from?
Mr. Sullivan, please, I think we are really straying away from the application that we have in front of us. We do understand your frustration, but I believe that we have heard now full submission from you. We've heard all your points. I'm afraid these points are just so not relevant. It's not something we can help you with. So there's little point in listening on. I do feel now we've got a good understanding of your concerns, and it'll be an opportunity now. There'll be some questions that are going to be asked of you, or there may not be some, but there may be some by members and the applicant's solicitors, and it may be in that you can further information to us and further question. Okay, so we do need to carry on with the process because we're in danger of not following process and a little bit of cross questioning there with our officers, which isn't helpful because the officer wouldn't be expecting that. Okay, so if we're all content, then looking for nods from members. Thank you very much. We will now go on to questions of other persons. So members, do you have any questions for Mr. O'Sullivan? Mr. Cook, I beg your pardon first. Mr. Cook.
Chair, if I may, could I just give Mr. O'Sullivan a bit of reassurance in maybe simple layman's terms?
Yes, you can.
Okay.
Thank you. Thank you, Councillor Kelsey. It'd be very helpful.
Mr. O'Sullivan, the application that is in front of us today is for what could happen if this licence were granted. If this licence is not granted, then it simply reverts back to how it has always been, which will be the ability to play music, etc., till 1 o'clock and have people in the garden till 1 o'clock in the morning. As a resident, if this is granted, then you have further rights, because if the company then continue to flirt, as is alleged, their responsibilities, you can then call, as you can at any time, for a review of their licence. So if this licence is granted today, and in your opinion, the company continue to flirt them with lots of people in the garden, lots of noise coming from the garden after the 11 o'clock time, then your direct action is to call for a review of their licence, where they will be called in to explain their actions, and it then runs the risks of even more conditions or the possibility of the revocation of their licence if the board so deems that is the suitable action to take. In my opinion, at this moment, if this licence is granted, it actually gives you far more protection than you've ever had with any premises on that site.
That's really useful. Thank you so much for that potted explanation, Councillor Kelsey. Extremely helpful, and I hope that both our objectors found that useful. Councillor Farquhar, do you have any questions for either of our objectors? Councillor Farquhar?
It's frozen, I think.
Chair, it looks like Councillor Farquhar has actually frozen.
I'll come back. I'll carry on and come back to him. Okay. Mr. McGregor, and if in your questioning, if you do have any questions, if you could attempt to be helpful, as Councillor Kelsey has, I'll bring him in a minute. I'd be grateful. Mr. McGregor.
I have no questions for either Mr. O'Sullivan, who we met on the call last week, or
okay.
Mr. Cook. I have some observations which I'll make at the end about.
Lovely, in your summation, that will be helpful. Thank you very much. Thank you. Going back to you, Councillor Farquhar, you froze for a minute there. Are you with us now?
Frozen again.
Oh dear. Okay, well, oh, there you are.
I will log out, log back in. Yes,
log out, log in. Okay, no worries.
Okay,
Mr. Greenfield.
just a moment.
Yeah, thank you, Mr. Greenfield. Do you have any questions for either of our objectors?
No, I don't have any questions.
Okay, I'll just wait for Councillor Farquhar to log in and out. And just Mrs. Jardine, do you have any questions for either objector?
No, no questions, thank you.
Okay, won't be a moment. Just have to go through process, have to offer the ability of the member to ask any questions. Hopefully it won't be too long.
Yeah, could I just come in briefly while we're waiting for Councillor Farquhar?
Thank
It's
you.
Mary Almeida, our legal advisor. Just to confirm with Mr O'Sullivan, I think Councillor Kelsey did confirm it as well, is that should the licence be granted today, then the additional conditions offered by the applicant would form part of that licence.
I'm reassured by that, so I can pursue the concern about plant and equipment as part of the license.
No, that's planning.
Oh.
No, because that doesn't form part of the terms being offered today.
No, you've had your advice with regard to that, Mr O'Sullivan. That's the planning. Okay, thank you. Councillor Farquhar, are you back with us?
He's frozen again.
Oh dear. Well, we do need our subcommittee member in the room, so I can't really continue. Can somebody call Councillor?
Can you hear me?
Yeah, we can hear you. You keep freezing, Councillor Farquhar.
I will switch over onto my mobile device, and then I can participate fully. I can hear you just fine.
Yeah, we can hear you now. You're great.
I can watch you just fine. So it's obviously a small stutter from my end.
Right.
Thank you. I did catch that advice to Mr O'Sullivan, and I thought Councillor Kelsey's observations were very, very useful as well. I want to be a little bit pedantic because a point came up, which, if you'll allow me, yeah.
Is this a question for either of the objectors, please? Because that's where we are. So if it's something, you've frozen again. Oh dear. We're going to have to switch over to mobile, I think, when we get Councillor Farquhar back. We've lost him again. Okay. Well, I think what we'll do is we'll move on. I don't know how long it's going to be. I'm sure that we can always have the question posed, should you so have one, out of process. That won't be a problem as long as we address it. Opportunity now with regard to our questions which have been put for summation. So I offer that first to Mr Cook. Mr Cook, you have an opportunity now to summarise your matters, and the floor is yours, and you have as long as you would require, but obviously a summary of what you told us rather than what you told us all over again. Thank you very much.
No, I won't bore you with repeating it all again. As I say, I appreciate that it's possible to split hairs and say this belongs to that.
Mr Cook, I'm sorry. I thought Councillor Farquhar was back with us, but he's not, is he? So we do need the member back. We can't continue without him. My apologies. There you are, Councillor Farquhar. Are you with us again?
I am.
I'll tell you what, Councillor Farquhar, just put your video off, then you'll give yourself a bit more bandwidth and we won't keep losing you. All right?
It's on his mobile device now.
So just put your video off and your bandwidth will reduce and you shouldn't be in and out. Can you hear us, Councillor Farquhar? Okay. Councillor Farquhar, can you hear us?
I am on a mobile device. I can hear you.
Yeah, well, the reason you're going in and out is because your bandwidth is restricted because you're on a mobile. So if you switch your video off, but you can hear us, we'll do it like that. So pop your video off and then just say hello so we can hear you. Yeah. Right. So where have you gone now? Nope, you've disappeared. Okay, I think Councillor Farquhar switched himself off entirely. Well, let's hope he's going to come back just on sound. I don't think it's a technical problem that we need to ask our technical professional to come in on, because it's just something on the device. Hopefully Councillor Farquhar will come back to us just on sound. Sorry about this. What happens with these remote meetings, we get the odd glitch.
Yeah, I didn't know if you maybe wanted to take just a 5-minute break for us to try and contact Councillor Farquhar and give him some help.
I think that might be a good way forward, Mr. Tyler. We'll take literally a 5-minute break, so we'll reconvene at 10 to 1. Is everybody happy? Get a quick cup of coffee and do whatever you need to do. We'll come back at 10 to 1. Thank you. Okay, sorry about that, anybody who's listening. We had a few technical issues. We lost one of our subcommittee members, which obviously is not convivial with us holding our meeting. So now Councillor Farquhar's back with us and we can continue. So I had asked, we had got summations, and I'd asked solicitor for the applicant. No, I haven't. We've got summations, and I had asked Mr. Cook as one of our objectors. It was his opportunity to summarise, and you're free, Mr. Cook. You have the floor, and please start from the beginning. Thank you very much.
Okay, I'll try and keep it very short. I appreciate that what Mr. McGregor and what the legal advisors have said about the various areas that you cannot look at today in terms of finding a solution to the problems that have been caused. But I do ask you to take into account all of those areas as part of the factual matrix of circumstances, which will be made considerably worse by turning the outside of this place into an open air pub.
Thank you very much, Mr. Cook. Okay, moving on then. Mr. O'Sullivan, you have the floor. Time for your summation. You just want to unmute yourself, Mr. O'Sullivan.
Sorry, I just about run out of battery on the
Oh dear.
on the Surface Pro. No, it's all right. I've just shifted around and got it plugged in.
Right.
I don't think there's anything that I need to repeat, really. It seems that a lot of what my concerns are not within your remit. So, yeah, I mean, the general point, really, I think, is that the increase in activity that the outdoor bar invites would presumably increase the level of nuisance and disturbance. And in particular, in our case, we're obviously concerned about the live music and amplified music and so on, and the other issues which are inadmissible. But otherwise, I think my points have been made, really.
Thank you very much, Mr. O'Sullivan. Mr. McGregor, you have the floor.
Yes, good afternoon. I shall be mercifully brief. I didn't ask any questions of Mr. O'Sullivan and Mr. Cook. It's not to say that I accept what they've said, and in particular, I don't accept the way that Mr. Cook has characterised the way that these premises operate. And I think it's safe to say that if they did operate in the way that has been characterised, then one might have expected the police and all the environmental health officers to have made an objection to the application and or to have commenced review proceedings before now, which they haven't. But I said at the outset that the irony is of the application is that if you grant the license or the variation to the application, it will provide greater protection to local residents than is currently the case because of the conditions that we have offered to be attached to and added to the license, and that will add protection to Mr. O'Sullivan, to Mr. Cook. It will be more strength to your arm as an authority, and also to the responsible authorities, in particular the police and the environmental health officer. And I would repeat the comment that was made by Councillor Kelsey, is that if this application is granted, then it provides more protection to the local residents than they've ever had before. And so in the absence of any representations from negative representations from the responsible authorities, and with the additional conditions that are being attached to the license, and focusing what it is that you're being asked to do today, which is to license a small external bar in the garden, I would invite you to grant the application.
Thank you very much, Mr. McGregor. Mr. Greenfield, did you have anything to add?
No, thank you. I'm happy with everything Mr. McGregor has said on my behalf. Thank you.
Thank you, Mr. Greenfield. And Mrs. Jardim, did you want to summarise in any way?
Nothing else to add. Thank you, Chair.
Thank you very much. Okay. So with that said, thank you very much indeed. I will now conclude the hearing. And at the end of this meeting, the subcommittee will adjourn in private with the legal advisor and the clerk to deliberate. Notification of the subcommittee's decision will be provided within the period of 5 working days, beginning with the day or the last day on which the hearing was held in accordance with the regulations. I can hear some backtrack there, not sure what that is. Notification decision will include information about the right of appeal as appropriate. And I'll now ask our legal advisor, Mrs. Almeida, if she will give us the information with regard to the right of appeal. Thank you.
Thank you, Chair. Yes, all parties have the right to appeal the review's decision within 21 days from notification of that decision, and any appeal is to the Magistrates' Court.
And I'd just like to thank everybody for attending, and to our objectors for coming on. It's always very difficult from your aspect because you are bringing it in from just your point of view. You don't have that expertise and knowledge, so you can be absolutely forgiven for thinking that there were things that we were able to do today which we actually weren't. But we've listened to what you've got to say, and we shall take all your matters into consideration with regard to our deliberations today. So thank you very much to applicants, to objectors, to officers. And I will now conclude the meeting. I would ask please that everybody leave except subcommittee members, my legal advisor and my clerk. Thank you very much and good afternoon to you.